Truth, whole truth, and nothing but the truth.
I swear.
Ms. Snavely, you talk about an incident in 2021
Yeah.
where you indicate that Mr. Peterson was intoxicated, was abusive to you, forced you to have sex,
Yes, Your Honor.
and that you then tried to work things out afterwards, and it hasn't worked out, and he's continued to contact you even though you've told him you don't want him contacting you. Do you have anything you want to add to what you had in your petition?
Um, yes, Your Honor. I just wish that all communication and contact would cease. That's all I've requested a couple of times, and I just want to go on with my life.
Okay. Mr. Peterson, anything you want to say?
Yes, I have a lot I want to say about this. This was done, in my opinion, unnecessarily. I have not seen nor communicated with her by phone, like through verbal communication, in 14 months. I live in the same place. I work full time. I walk to work, which is 5 minutes away. I have no contact with her. And the one thing that I really want to address is when she said that I forced her in that vacation, that is totally perjury because she initiated it. And not only did she initiate it, it says, forgive my language, that we did anal. She wanted to do that before and after. So none of that is true. And the only contact that has been made between us has been me asking her to remove her belongings because I did not want to throw out someone's stuff. And she refused to get her belongings. And her last message actually was, do what you want with them, throw them away. And then she found out that I had messaged one of her friends to go for a hike and I get a restraining order. But we have not had any contact. I've never threatened violence on her. I've never hurt her. I've never laid a hand on her. I've never done anything to her. And pure communication was all about getting her belongings. That's it, Your Honor.
I mean, I'm looking at an email from the 23rd of April of this year.
Yeah.
Okay.
I was not, sorry, Your Honor.
Go ahead.
I said I was not able to submit any evidence in. I did not have enough time. I did not know you needed a week beforehand, and I had been served just a few days before that. And I'm not sure what selective emails were submitted to the court by her because it could look out of context.
Okay. Well, the emails are, I mean, you know, they indicate that what you told me is inaccurate because I see there's conversation back and forth about her belongings, but then it spills over into the relationship talk. And looks like I see emails from you on the 23rd of April, the 17th of April, I think the 16th, the 15th. So explain that to me.
Yes, I was. She would talk to me about the relationship. She says in the papers that she changed her number, blocked it, and did all this stuff. The only reason I had her number or her email was because she reinitiated contact with me, and once in a while she would talk about the relationship, and I would re-engage. And she gave me hope for about 6 months that we were going to get back together, and it never happened. And towards the end, it was totally civil until she kept saying that she was going to get her belongings and she wouldn't. And I have a small apartment and I have had them for 14 months. And yeah, I was a little bitter about the relationship, but I sent her an email and I was being very civil all the time with her belongings. I told her I would, when she told me to throw them away, I said, okay, but I will dispose of anything that is fragile or mail and stuff like that in an appropriate way, or save it for you, because I don't want you to lose your pass and I don't want you to lose your stuff. And even though we had those issues with our relationship and still had a little bit of bitterness between each other, I still maintained I want to get you your belongings. I did not hold that against her. She just would always say, I will come this day. And then she said, the last one of her last messages, she said, um, she took, I can't remember verbatim, but she said, I can't find a time to come and pick them up. Do what you will with my stuff and throw it away.
Right.
So,
all right. Ms. Snavely, it's hard for me to tell with what you submitted as to who initiated the most recent email exchange. So you tell me how that happened.
I'm not sure who initiated the most recent email exchange. I would have to go back into my emails and see if I still have all of them. I have multiple times tried to arrange with James to come get my belongings, and due to the nature of our splitting last year in the spring, I tried to resolve with him times that either I could have somebody else come and get my things, or he could be not there when I got my things. And we were never able to come to a agreeable time or situation in which I was allowed to come get my belongings. There was a couple of different occasions on which I had somebody with a flatbed trailer lined up to come help me move my things, and James just got upset about something and said, well, I've already thrown your things away. They're gone. And I don't know if he did have my things 2 weeks ago still. I don't know if he got rid of them a long time ago. It's been back and forth a bunch of times on whether even if he still had my belongings. And at this point, I know that I'm not ever going to get them back. He's made it to where I cannot come get them. There's no time or situation that works for him that works for me. And so I wanted him to stop communicating with me. And I said, please stop, or else I will go to the police and file for an order. And he sent me a nasty message after that, and I just didn't respond to it. And then he sent me another one talking about how he's going through my things, and he found pictures of me and my ex who passed away. And he said, I hope it's him, and that he enjoyed destroying the pictures or something along those lines. And this is the continued nature of when he reaches out to me every so often. It's mostly just to be mean or cruel. And I just want him to leave me alone, and I don't want him to email me. And
all right. Thank you.
Your Honor, can I respond to that?
Hold on, Mr. Peterson. So I'll ask a couple questions here, Mr. Peterson. Are there any personal belongings of Ms. Snavely that you still have?
Yes, I kept all her mail and all that stuff because I wasn't sure how to dispose of that properly without it being tampered with or someone finding it, or, anyone using her information. And I never once said I threw away her stuff, and never once.
All right. Yeah. Well, all I need to know is you still have some of her belongings and you are willing to return those?
Yes, her sensitive stuff, like all her mail, all her, whatever that pertained to her name or was related to her, as in documents and stuff like that, I still have, because I did not want someone else to get in possession of them.
And how can you return them to Ms. Snavely?
I told her, that's the thing I wanted to respond to, is not once was there ever a situation where she said she had a vehicle ready and she could pick stuff up, because I have stated in emails saying
I've read the emails where the two of you are going back and forth about that. Do you have a plan for getting them back to Ms. Snavely?
She can come and get them whenever she wants. I said I can put them outside the door. I can leave and have someone else be here. I said I will do anything. Just please come get your belongings. Okay. And she just said no. She doesn't have time.
Mm-hmm. Okay.
Your Honor, I was given a time frame in which doing this last.
Right. Yeah, I've read the back and forth where the two of you haven't figured out how to make this happen. Can you put it in the mail, Mr. Peterson? It's just documents.
It's a lot of documents, so it would have to be shipped, and
Okay.
Yeah,
All right.
I don't think that's plausible.
Okay. Do you want this stuff back, Ms. Snavely, or have you given up on it?
I've given up on it, honestly.
Okay. Yeah, I'm not in the position to negotiate how to make this happen. Seems to me it could be a fairly easy resolution. Like Mr. Peterson, you could just put the stuff outside your door and just leave it there. And if Ms. Snavely sends somebody to pick it up, then it gets picked up. And if after a week it's still there, then you can dispose of it. You know, there are all 1,000 ways to do this.
I suggested that. I just didn't want.
Okay, yeah. We're not gonna, like I said, I'm not gonna negotiate it. Just pointing out the obvious here.
Yeah. And Your Honor, may I add that I do not mind the no contact or anything, because I have no intention of contacting her further. And I have no idea where she lives, and I stay within a 1 mile radius of my house, so I have no issues with that, if that makes her feel more comfortable.
And Ms. Snavely, two of you resided together, is that right?
Yes, we did, Your Honor.
In my apartment.
Based on the acquiescence of Mr. Peterson, I will grant the request to enter a protection order for a period of 1 year. And during that time, Mr. Peterson, no contact at all with Ms. Snavely.
Yes, sir.
And Ms. Snavely, if you want the order renewed, you'll have to come back to court and ask for it to be renewed.
Yes, Your Honor. Yes, Your Honor.
This order does not need further service since Mr. Peterson did appear and had previously been served. All right. Thank you both.
Have a great day, Your Honor.
Thank you. You too.
Your Honor, may I approach the bench? Get away.
Thank you.
We're actually going to be motioning for a continuance. I'm providing a copy of the NOA to the petitioner. I'm filing it on behalf of Luke Laughlin. He will be the attorney of record. I'm just stepping in today for coverage.
Okay, thank you. Ms. Bergkamp, essentially, Mr. English is here on behalf of an associate, Mr. Laughlin, who looks like he's just signed on to represent Mr. Kohler, and they're asking for a continuance so that they can appear, Mr. Laughlin can appear on behalf of Mr. Kohler. Do you have thoughts on that issue?
I do have a statement.
Well, I mean, I understand, I've read the petition and I understand what's set forth there, just on the issue of the continuance.
I would be fine with the continuance. I don't know what my options are. So do I have an option in this situation?
You can argue to me why you don't think a continuance is appropriate in this case.
Well, honestly, I feel like my petition speaks for itself. And I've provided a lot of evidence that Mr. Kohler actually disclosed on his own through social media. And I feel like I've done my part, and it is not my problem that perhaps he, wasn't able to get his legal counsel arranged for today.
Okay. So let me ask it this way. I believe the primary concern set forth in the petition was your belief that Mr. Kohler was responsible for spreading the keys around the county.
That's correct.
And I can't remember from the petition, this occurred roughly when?
It started back on March 8th of 2023 and went through early May of 2023.
Okay. So has there been any contact in any fashion towards you from Mr. Kohler in the last 3 months?
No direct contact, just with the agency that I work for.
Okay. Any of it directed towards you?
They are public records requests regarding work that I do at that public agency.
Okay. But nothing by way of a threat or any emails, texts, posts directed towards you in the last 3 months?
The one post that I would point to is, which I just learned of recently, was on November 29th, where he refers to me by my initials. And I'll read that post.
Okay. I think that answers the question I was, without even getting into the substance of it. All right, I'll grant the request to reset this. We will continue with the protection order as originally entered in the temporary form. And that'll remain through the hearing set now on the 20th of May at 9 o'clock.
Your Honor, can I make a request for the hearing? Mr. Laughlin wanted to return preferably during the week of June 17th, either on Tuesday, Wednesday, or Thursday.
It would be a Monday.
It would be a Monday. Then Monday, the
17th. Mm-hmm. Do you have any objection to maintaining the temporary protection order through the 17th of June?
No, I don't.
Okay. Okay, I'll just go ahead and write it in. Oh. I can do that too. I'm pretty sure you're not Mr. Kessler.
No, Your Honor. My name is Peter Lindgren. I'm an associate with Mr. Kessler's firm. Mr. Kessler is in trial this morning, and he asked me to stand in for him.
Thank you. Thank you. All right. It appears the two parties here are neighbors, and just a very general summation of the petitioner's petition, as I understand it, is that Mr. Parfit yells over the fence at you. He peers over the fence, and he's making you uncomfortable in your own yard. Go ahead and add anything else that you think isn't caught by that summary.
No, that's about it, Your Honor. We put up an 8-foot fence to separate our world from his world. We've asked the home association to give us that permission to raise the fence just for that separation, but yet he still figures out a way to. It's like that's it. That's all, Your Honor.
And the safety of our granddaughter, who was here the day that he threw the branch over the fence.
All right. And when did the screening fence go up?
We started it last year.
Yeah, it was meant to be a slow process. Just whenever I got paid, I'd add a little bit to it. But when he started the harassment thing, we actually had to charge a lot of stuff to put the fence up. And then later on, we added sensors around the fence because it still didn't stop him. And then we added security cameras. He didn't seem to care about that. So we called the homeowner association to give us permission to raise the fence. And it's still not doing anything.
All right. And from the Benevente standpoint, what's your opinion as to what precipitated this, the nature of this relationship?
Well, it was an issue that I did, and it was my mistake, and I admitted it to it right off the bat, is that when I was working on the fence, what I thought was the green belt, there was a tree growing over into my yard. And there was I had to cut through 6 feet of blackberries and brush to get to that tree and cut that off so that I could continue my fence. I did not know at the time that it was private property. It looked like the green belt to me. And when he brought it to my attention, I apologized. And he said he would see what his attorney says about it. And that same afternoon, I looked out and he was grabbing my rope and my pulleys and my chains off the green belt and throwing it on his property. And I said, dude, that's my stuff. What are you doing? And he said, it's mine. So my property now, what are you going to do about it? That's at the point when I thought, I'm not dealing with a rational individual here. So I just kind of walked back in the house, and that's the way it's been ever since.
All right. Thank you. And Mr. Lindgren, do you have any questions for the Beneventes?
No, Your Honor.
And you wish to have Mr. Parfit testify?
Yes, Your Honor. I'm also prepared to defend the motion or defend the Mr. Parfit's response to the petitioner's petition in this case. But if there's something you'd like to hear from Mr. Parfit.
Okay, we have not received a written response. So if there's a written response, it's not in the file. So Do you have a written response from Mr. Parfit?
I do, Your Honor.
And have the Beneventes received that?
We have not.
We have not.
Okay. So I think since I don't have one and the Beneventes don't have one, I think the way you're going to have to do that is have Mr. Parfit testify today. And since you have a statement, you can use that as your basis for asking him questions.
Very well, Your Honor.
Okay, so I'll just remind Mr. Parfit, you're under oath. Okay, go ahead, Mr. Lindgren.
So you want the whole story? Can I ask for a continuance?
Here.
Okay.
So we've heard what the Beneventes have had to say.
Yes.
And Mr. Lindgren, as your attorney, can figure out how best to respond by asking you questions concerning what you believe the facts are.
Okay.
Okay, Mr. Lindgren, go ahead.
All right. Mike, in August of 2023, how did this dispute begin?
Prior to, or sometime in the beginning of early August 23, me and my wife noticed a large gap in the Greenbelt property line owned by the HOA. And I went to go look at the property line, and I saw numerous trees from the Greenbelt, plus one large tree in particular had been cut down. Prior to that, prior to me going into the Greenbelt, I delivered Mrs. Benevente a note, which I believe is in evidence, that said, "Can Roy contact me to talk about the tree he took down?" She told me that he was on the river fishing and she would get him the note. I went into the Greenbelt and I went onto our property corner. I had rented a special tool that'll find a surveyor's hub. And I was looking for the property corner when within 20 minutes, Mr. Benevente approached me in the Greenbelt and on my property, demanded to know what I was doing on his property. I wasn't on his property. I was on my property in the Greenbelt. In his statement, he states that, or somebody states that I accused him of taking the property stake. I never once accused him of taking the property stake. He actually showed me where it was. It was under the cover of an iron pipe. So I pulled the iron pipe. I checked with the special metal detector, and that's the property corner. So I said to him, I said, if this is the property corner and that's the tree on my property, then you cut down my tree. And prior to that, we had a conversation about he had gotten a plot map from the county and that the map was wrong. And I told him it wasn't. I asked to look at his map. He said, no. I said, do you want to look at my phone? Because I was on the website for the county. He said, no. He said, I could go buy a map from the county office like he did. Then we could look at my map.
Okay, so let me just stop you there so you understand what I need here. I'm not going to be able to resolve any property issue if there's any dispute about that.
Right.
Okay. What I'm concerned about is the relationship between the parties as a result of this. So focus, if you'll focus your questions to Mr. Parfit about that, about how whatever transpired between the parties after that is what I'm looking for. So
I've met them on 4 occasions. Once I delivered a note. Once I talked to both of them through a closed front door with a witness. The other 2 instances was on April 31st when he approached me in the Greenbelt and on my property, and then August 31st. And then on April 13th, I was in the Greenbelt cleaning up the tree he cut down and some other damage and things like that. And they beat on their fence to get my attention. I was running a chainsaw. I had hearing protection in. I had hand tools, and I hollered, "I'll talk to you when I'm done." When I quit running the chainsaw, I went and stood on a stump in the Greenbelt, looked over their fence, got their attention, and asked what was going on. What did they want? Whatever. We had a verbal altercation. They said I threw a branch over the fence. I told them it wasn't on purpose. I'm cleaning the backyard up. I'm throwing branches and stuff behind me, running the chainsaw. I mean, you see the video, you do see something go over the fence. It wasn't intentional. I didn't.
Okay. Since that date, have you had any contact with the Beneventes? No. And do you on any regular basis look over their fence outside of the incident you just described?
No, not on a regular basis. No.
Okay.
Mike, When you asked the Beneventes to pay for the tree, did you leave when they asked you to?
Yeah. They submitted a video. It shows 15 seconds of them asking me to leave the property, and that's what I did. It doesn't show maybe the minute or longer before that where he told me that we could talk through the door. There's none of that in context. It's just them yelling at me, asking me to leave their property, which I did. I've never been on the property since.
How many times since the tree was cut down do you think you've interacted with them?
Since the tree was cut down, twice. When I talked to him through the door about the damages, and then on April 13th.
Have the petitioners ever tried to seek a protective order against you before?
Apparently, this is the second time. I wasn't aware of anything the first time around. They make a statement that they tried to get an order sometime last year, I'm assuming, and it, I don't know, was squashed or null and void or something. I don't know what happened. I wasn't even aware of that.
Have the petitioners ever called the police on you?
Yes. On March 8th, it looks like there was a call made that I was sitting in front of her house and I would park for a few minutes and drive away. I did a PDR. I got the audio of the 911 call, and I did another PDR, and I got the officer's notes. In either through the notes or the audio, there's no description of me. There's no description of the vehicle. I've never intentionally parked in front of their house. Also, in that audio phone call, she references something to the effect that I threw the top of the tree that they cut down on top of their shed. And that's not what happened. Prior to her calling on March 8th, we had some windstorms or something like that. And we lost another tree on our property. And it went down into a healthy tree on our property. It went into the damaged tree that the Beneventes cut down, and it fell across their fence and onto their shed. It was still attached to the ground. We didn't hear anything from them or anything. On April 13th, we went out there, I cut up the tree that fell over, pulled it all off of their fence and off the top of their shed from my property line, got it out of there, untangled it from our healthy tree, and I cut the tree up that was on the ground. When they approached me on the 13th, they never said anything to me about throwing the branches up on top of their shed. And it wasn't the branches from the tree he cut down. It was from a tree that fell down. The root ball was still attached to the ground, and we just cut it up. It was our tree. We cut it up. We pulled it out of their fence and off the top of their shed. But part of this, you don't have that. They don't have that, because the documents I got say I have 7 days to file any evidence, and I didn't get 7 days to file it. And there's another RCW something, the sheriff has to serve me with 5 days, and I wasn't even served with 5 days. I've had basically 3 business days to do PDRs, to find an attorney, to get things put together.
All right. Thank you. Go ahead.
Mike, during the interaction over the branches falling in their yard, the first one, were you carrying a firearm or some other kind of weapon?
No.
And is it true that it has only been 4 court days since you were served with this?
Yeah, I was served on Tuesday afternoon, about 1 o'clock in the afternoon, with a court date on Monday morning.
No further questions, John.
All right, thank you. Beneventes, anything else you want to add?
You know, Your Honor, we just want to be left alone to live our lives. We don't care about what goes on outside. Like I said, we apologize for the tree, but that apparently didn't stop him. We just want to enjoy our retirement years and just enjoy our backyard. That's all.
All right. Thank you. I've listened to the testimony of the parties in this case, and I had previously reviewed the exhibits that had been filed by the petitioners. And I do understand that Mr. Parfit was indicating that if given his preference, he would ask for more time to prepare. But after hearing all of this, I'm going to deny the petitioner's request for a protection order. Thus is why I'm not addressing the respondent's request for a continuance. It appears that there's been this dispute over apparently the tree led to some contention between the neighbors, and the relationship sort of went downhill after that. But the contacts have been limited. I don't have any evidence of any contact subsequent to the 13th of April. And I don't find in here a basis for me to enter a protection order. So I'm going to deny the Benevente's request for such an order. What I will indicate, Mr. Parfit, is one, if you're seeking reimbursement for the cut tree and an apology is not enough, make sure any contact is through counsel, not through you.
Yes,
Don't go to the door and hand them a bill or anything.
Yep.
They've made clear they don't want contact from you.
Yes, Your Honor.
And they're on their property, you're on your property. They don't want to have discussions about the property. If you have objection to how they're administering their property, or if you think they're cutting your property or the greenbelt or whatever, either go to the HOA or contact counsel and have counsel contact them.
Yep.
But you can see how we're here in court because of the nature of the contact. I watched the video and I heard both parties yelling, so I understand that. I just strongly suggest that you avoid contact with the Beneventes in any fashion unless you're going through third parties because you have certain issues.
And
the Beneventes understand the nature of this, and I would strongly suggest Mr. Parfit is also asking that you not contact him directly, and I've heard you say all you want is peace on your property, so I suspect you'll be happy not to contact Mr. Parfit. So hopefully this will bring we'll put this issue to bed for now, and hopefully this will bring some at least peaceful coexistence. You may not have to become best friends, but as neighbors, each party would probably like to enjoy their property peacefully without feeling under threat from the other. So let's see if we can leave it that way.
Understood.
All right.
Thank you, Your Honor. Thank you, Your Honor.
Thank you. We'll give you a copy of the order. And for the Beneventes, you're not present, but a copy of this order will be available to you in your electronic file with the court.
Thank you, Your Honor.
All right. Thank you.
All right. Thank you, Your Honor.
Okay. Thank you. All right. I know I saw the parties on Friday in regards to the appeal of the small claim ruling. And I had told you at the time, I knew you were coming into court today. I had previously reviewed the petition in this case, and so I am familiar with the issues raised. Ms. Hobson, Mr. Landis is serving as your counsel, is that right?
That's correct.
Okay. Yes, Your Honor.
All right. Frankly, I'll just ask, well, since you're represented by counsel, I'll go through Mr. Landis. Mr. Landis, as I've indicated, I've read Ms. Hobson's petition, I've reviewed the other documents, and also reviewed the response from Ms. Robert and associated documents. Do you have any other factual testimony you wish to have elicited prior to making argument in this case?
I don't believe so, Your Honor. If Your Honor has any particular questions or something comes up from Ms. Roberts' testimony or Mr. Roberts' testimony, we'd like an opportunity to respond if need be. But I think the record is pretty complete in terms of the evidence that we have filed.
All right, thank you. And both parties have filed fairly extensive evidence, and I have reviewed it. So I just want to indicate that to the parties. All right, Ms. Robert, do you have anything you want to add that's in addition to what you have already filed?
There was new evidence presented and I quickly responded.
Okay, you're going to need to really speak up because you're coming in very soft.
Okay, can you hear me better?
That is better, yes.
Okay, thank you. The response filed by the petitioner just a few days ago, I attempted to respond to rather quickly, but they brought up new questions regarding why we hadn't filed any additional or served them with any additional official notices from the property manager. And she's here as a witness just in case that's even relevant.
Okay, and is that Ashley or Kylie?
That's Rachel Taylor.
Rachel, I'm sorry. Okay, I bet I know Ashley and Kylie. Okay. And so nothing else factually, Ms. Robert?
No, I presented everything.
Right, thank you. And Mr. Landis, on behalf of the petitioner, your argument. And once again, I read your declaration that you had filed recently.
Thank you, Your Honor, and I appreciate you going through the record. It's fairly long and voluminous. I think just to simplify and cut to the key elements here, the respondent doesn't deny that there was electronic surveillance of both of my client's children and at least 6 of their friends on multiple occasions. The justifications that she provides don't really hold water. Primarily, the law does not immunize unwanted surveillance or monitoring or tracking, even if it's on a public or open portion of a social media site. The key is whether that monitoring and tracking makes someone, adult or child, feel frightened, intimidated, or threatened. In fact, the worksheet for the protective order petitions that the court issues makes that clear. It specifies 3 questions that a petitioner has to answer. One is whether the other person has contacted, attempted to contact, monitor, or tracked, kept under observation, or follows you. Number 1. Number 2, that the behavior happened 2 or more times. And number 3, you feel intimidated, frightened, or threatened. And in fact, the respondent does not contest that my client's children felt intimidated and threatened. And in fact, the same is true of the 6 other children, minor children, teenagers, that were contacted multiple times on the social media sites. One of them, in fact, made it clear that Ms. Robert had done it again, and it was actually scary. And what concerns us in this case is that even after Ms. Robert was notified by my client of the concern to her children and a request that it stop, and even after my client notified her other landlord, Ms. Robert's husband, at length about the concern that she had and the concern for her children's well-being, there was no response whatsoever. Not at all. No shred of concern has ever been exhibited by the respondent for that issue, which is really the key to a protective order. In addition, the respondent did try to contact or access the private sites several times, not just once, several. Once in April 2023, she attempted to access the private portion of Juliet, my client's daughter, her social media site on Instagram. She was blocked. Then earlier this year, she tried.
Mr. Landis, let me interrupt just so we can make sure the record's clear. And by access, you mean by submitting a request to either in friend and Facebook, or I can't remember what they call it on Instagram, but you have to file a friend request essentially, and that's what you're referring to?
Yes, Your Honor, that's essentially right.
Okay, all right, go ahead.
And so that happened twice, as far as we know, to Juliet. And the second time was earlier this year on a different social media platform called Snapchat. And in that same week, Ms. Robert requested access, again, requested being a friend to one of Juliet's very good friends, Lauren, also on Snapchat. So the key here is that this happened multiple times. There is no defense that it was only on an open portion. That isn't something that the law immunizes. And finally, and most importantly, it caused emotional distress, considerable emotional distress to my client's children and her friends, and my client and her husband as well.
All right. Thank you, Mr. Landis. And Ms. Roberts?
Good morning, Your Honor. I'd just like to respond kind of point by point. I absolutely have not attempted to contact in any way these youth. I have not messaged them, emailed them. I have only viewed the profiles. It's, as I said in my answer, it's possible that on Snapchat, the follow button is rather large. And when you're on your phone, it's super easy to hit a follow request and attempt to follow that person. It's not like a friend request. It's just, Snapchat doesn't even have like, it's a messaging platform. It's not really, as far as I'm aware, it's not like stuff that you don't post things. And I have no need to be friends with these kids. I have no need to message these kids. I was just screenshotting the evidence as I saw it on social media of parties at our house, things involving our house, and multiple children, multiple youth that are at the house are simultaneously posting, hey, you know, here's a selfie. We're at a party in the backyard. Here we are with all of our friends of like 25 and 30 kids. And the petitioner had previously been put on notice that this was absolutely unacceptable in our property. And, you know, they're climbing in the trees, they're dancing on the roof. And so I just merely was trying to document the evidence of the lease violations and the shenanigans that were ongoing. I've never contacted anybody. I've never messaged anybody. I've never followed anybody, attempted to follow anybody. We live 2 hours away. I'm not we're not at the house while they were living there trying to monitor the comings and goings. I have third-party reports coming to me from the neighbors who I know because we lived in that home for several years, and they are telling me, hey, there's another party at your house. There's another thing happening. There's cars lining the street. I've produced multiple pieces of evidence of the documentation that came from social media, that came from public, open social media. So I have no reason or desire to be contacting these kids, and for that matter, for the, or anyone related, friends, whatever. So I don't believe that they're afraid because all their social media things are public. If they're afraid, they'd make them all private. They're all public. They post stuff out there because they advertise parties online and they want everyone to see what they're up to. It's part of that, youth culture, but it requires, in my opinion, it requires parenting to say, gee, what are you putting out on social media? And what does that say about you and what you're doing? And, when they're posting photos with, beer cans in hand, it's evident what's going on. And I merely was trying to document that for our own purposes because these people were renting our home. And over the course of 3 years, there is extensive damage to our home. And it's kids running amok and just people not taking care of things, people claiming no responsibility for damages, for behaviors, even though they say in an email, yes, I'll make sure.
Okay, I'm not the small claims court, so I'm not going to get into the issue of
I understand
damage and responsibility.
The line's definitely blurred.
All right, so Ms. Robert, you'd indicated that you had made no attempts to contact them, but I saw screenshots of at least 2 friend requests. So to me, that seems like a desire to contact or to get access to private displays.
Which screenshots are you referring to?
Well, your name appears on a couple.
that's just that I viewed the profile, or that I viewed the open profile, not that I was attempting to be a friend. And I think they're the same one, even though they're listed separately. Let me find.
Okay. Yeah, I mean, my understanding is those are friend requests where you're asking to participate in their particular postings. I don't know that that automatically happens if you just log in and look at their site.
For Snapchat, that's the one I think was inadvertent. Like you can just be scrolling on your phone and accidentally hit the blue bar because it goes all the way across, and that then sends a follow request. It's not a message. It's not anything. It was inadvertent. It wasn't on purpose. My phone is fairly small, and it's easy to accidentally hit it, I guess, when you're looking at the open profile. Like, it's a public profile, anyone can look at it, and then to accidentally hit the follow button is something that is very easy to do and wasn't done intentionally. The exhibit 4 is the only one I see where there's a request. The rest of them just say that I viewed the profile along with multiple other people who are also not friends who have viewed the profile. That's all I see. One accidental on Snapchat. On exhibit exhibit 4. When it says follow next to it and it's red, that's, you press that button on TikTok if you want to follow that person's TikTok. That was not what I was doing. I never clicked that. If I did, it would say follow back. Exhibit 3 and exhibit 4 are exactly the same incident. So it shows exhibit 3 that I added someone on Snapchat, and then it shows an exhibit 4 except, added except friend. That's the same situation. It happened one time and it was accidental, and it was a year ago when I was first looking at all the social media, trying to determine what was going on at our house because of the.
Okay, and exhibit 6.
Exhibit 6. Exhibit 6 just shows that profile views. There's 2 exhibit 6s. One says 907 at the top, and it just shows that I viewed a profile. It doesn't even show whose profile I viewed. And the second exhibit 6 shows 108 at the top. And that again just shows that I viewed a profile, not that I attempted to follow them. Just that I.
Okay. All right. Thank you. Mr. Landis, you get the last word.
Your Honor, as my client's declaration and her initial petition makes clear, there were multiple attempts to access, but not only of her children, but at least one of the friends. As you can imagine, it is the only way to capture that evidence is if the child at the time takes a screenshot of the attempt. And what we provided were examples, and it's not exhaustive. I'm relying on the declaration of my client, and certainly if it becomes an issue, we can ask each of the other friends, the other minors, to submit declarations. But I think the important thing here is that whether it's on a public, whether she accessed a public portion of the site or tried to get access into the private portion, the law makes no distinction between the two. The law forbids unwanted surveillance, even if it's through, peering through a binoculars on somebody's sidewalk or a public park or following them. It's that there is no distinction that the law makes that requires actual intended access to a private portion of a social media site. But Your Honor, I would like to make a suggestion about how I think we can resolve this dispute fairly readily, if Your Honor is willing to hear that.
Go ahead.
My client and her family have moved out of the house. The tenancy is over. And so the justification that Ms. Robert has provided to previous monitoring of the social media sites, whether or not it was legitimate at the time, it is no longer any reason whatsoever to conduct any observation of public or attempted private sites. And so if Ms. Robert simply promises here in court not to continue the behavior, not to do it again, and apologizes for any emotional distress that has been caused to these children, then we will withdraw the request for the protective order.
All right, thank you. And Ms. Robert, do you want to respond?
Yes, Your Honor, there is one more thing I wanted to respond to, and that is, we actually hired a property manager for
right, okay, hold on. Just with Mr. Landis has indicated there'll be a withdrawal of the petition for an order if you're indicating you have no desire to further contact the parties.
I agree, Your Honor. I have no desire. The only contact I'm going to need to have is with the parents, and that's regarding damages to our home.
Your Honor, Your Honor, may I say something? Only because of the fact that in regards to this situation, I feel that the testimony from us is actually super important, because there is a piece in regards to what Greg is saying in regards to his request for her to cease those things because they're out of the property. I would like to state that the Roberts actually came and hired management because they wanted no further contact with them due to the fact that the harassment from what the only reason I feel like this is somewhat
Ms. Taylor, hold on. Ms. Taylor, hold on. What's your relationship here? Are you one of the property managers? You're muted.
Yeah, and the reason I feel it's somewhat relevant is because...
Okay, I'll decide whether I need you're one of the property managers?
Yeah, and the owner of Pettit Property Management, yes.
Okay, so do you agree that Ms. Hobson and her family have moved out?
They have vacated the property, correct.
Okay, all right. Okay, so I've heard thank you. I've heard Ms. Robert indicate that she has no further interest in contacting the children of Ms. Hobson, either directly or indirectly. And obviously, and Ms. Taylor is the one responsible for closing up the property and moving it along. I can't imagine any interest you would have in the activities of the children going forward. Is that accurate? Ms. Taylor, is that accurate?
That would be accurate. My concern is that Greg Landis has actually told the tenants, even though they have vacated, in multiple correspondence since we took over, that we are not the point of contact. And they refuse to go through us and keep going to the Roberts directly due to his, and I have written proof, his direction.
All right. Thank you, Ms. Taylor.
That's why I think it's important.
I'm not going to get into that. Okay. Mr. Landis, as their attorney, is representing them, and he'll take actions he believes is appropriate. So, all right. I'm going to note the withdrawal of the petition by Ms. Hobson and indicate that Ms. Robert has agreed not to reach out to the children. And this doesn't, this doesn't create a barrier to the parties, the adult parties contacting each other in regards to the current ongoing dispute over the tenancy and any damages that may have resulted therefrom and the return of the deposit. Those issues are issues that adults are fully capable of handling through the processes that are created. And that would be the expectation. I will say, frankly, that this was going to be the result, in my mind, whether Mr. Landis had suggested it or not, because I do think that posting things in public arenas is basically inviting observation. So as I suspect lots of landlords review public postings of tenants to make sure that what they're saying is appropriate. If people want what they're doing not to be observed publicly, they probably ought to take more precaution. You know, who else does this? Law enforcement does it. The number of convictions that are obtained when somebody posts things online, and, you know, I wasn't there, but then it shows them there with the knife or the gun in the hand, you know, whatever. You know, else uses it? Schools. Kids applying to college. What do they like? Colleges peruse their social media all over the place, looking to see what are they really like. So it's a fairly common thing, and the expectation these days, and this is coming from somebody, me, who I am on no social media, so for a very intended purpose. But those who decide to put themselves on social media are opening themselves to observation by folks way beyond their intended audience if they put it public. And so there just ought to be caution. And Ms. Hobson's sitting right in front of me, and she's hearing me say this. And I'm just indicating that from where I sit, that would be, I would hesitate to restrict people's ability to observe what is appearing in front of them directly. Now, I also agree that since the tenancy is ended here, there would be no basis for Ms. Robert or Mr. Robert, or in fact, Ms. Taylor and the agency that is administering the property to then peruse anything going on with the kids, unless somehow they show up back at the property having a big party or whatever. But beyond that, they should not be observed in their, you know, social media gathering. That would then indicate to me a surveillance that's going on, because there's no reasonable issue that either the Roberts or Ms. Taylor would have in the activities of the Hobson family. So I will sign the denial order with that understanding that there will be no further looking at the public media of at least the children of Ms. Hobson. And the parties as adults can continue in their attempts to resolve the legal issues that have previously been before the court, and I know are now moving on to an appellate review. All right, and Mr. Landis, I'll sign an order to this effect, and it'll be available in the district court file for the parties, and same for the Ms. Robert. I'll sign a denial order. Okay.
Thank you, Your Honor. We appreciate your guidance in this matter.
All right. Well, thank you all. Okay.
Thank you, Your Honor.
You're welcome. Thank you.